Okay, I think we are good to go. Once again, good afternoon, everyone. My name is Eduardo Paredes, and I'm a communications and outreach intern with ARP Idaho. I want to welcome you to today's NKA class about Advance Directives. Before I introduce our instructor, I wanted to give you a quick overview about NKA and then share some ground rules. So a little bit about NKA and the history of it. Over 15 years ago, a group of dedicated volunteers came together to create a lifelong learning program in Pocatello in partnership with Idaho State University. The volunteers looked at many different models and decided to create new knowledge adventures. And they wanted to make sure that NKA had these components. They wanted affordable access, volunteer governance, volunteer instructors, and active engagements from the community. And they wanted the membership to provide diverse, high quality educational experiences. And above all, they wanted the classes to be fun. In 2014, ARP Idaho State University Meridian, and the Treasure Valley YMCA formed a partnership to expand NKA to the Treasure Valley. And even though YMCA is no longer a partner, NKA Treasure Valley continues to offer dynamic and compelling lifelong learning opportunities to seniors. As most of you know, NKA is volunteer driven, and we are so thankful to receive the time and knowledge from our instructors to bring NKA classes for free. And then a few ground rules. Participants can leave the class at any time. Microphones will be muted. If you have any questions, feel free to put them in the chat and I will be reviewing those and then passing that information to our instructor today. Make sure that you have professional language and behavior during the class. And as a reminder, if you have to leave for any reason, this class is being recorded and will be made accessible on YouTube later on. All you have to do is go to YouTube and search NKA Idaho, and you should be able to find this class and any other classes from NKA Idaho as well. Now I am pleased to welcome Sunrise Ayers, Deputy Director of Idaho Legal Aid Services and practicing elder law attorney, as our presenter today. And with that, I will give the floor to Sunrise.
Thank you so much. So yes, my name is Sunrise Ayers. I've been an attorney with Idaho Legal Aid for 15 years. Next month it'll be 15 years. And I started out with Idaho Legal Aid working on our senior hotline, taking calls from seniors with a variety of civil legal questions. And I did that, worked on the hotline for 10 years. So that's my background in the area of elder law. And then I also represented senior clients in cases such as helping them draft advance directives and helping folks qualify for Medicaid and consumer law issues, things like of that nature. So that's my background. What I want to talk about today are a couple of issues around advance directives, why advance directives are important to have, what the different types of advance directives are, and some things that are important to know when you have advance directives in place or when you're drafting them, so that they're less likely to be abused or misused. So this is sort of an overview roadmap of where we're going to be going, what we're going to be covering today. So I want to start with just some quick definitions because I'm going to be using these terms throughout the class, the presentation today. So want to make sure we're all familiar with the language before we jump in. So a power of attorney is a document that gives one person, we call that person the principal. They use the power of attorney document to give some type of legal authority to another person, and we call that person the attorney in fact. And so the principal uses the power of attorney to name an attorney in fact who can act on their behalf. A power of attorney can be broad in scope, or it can be really limited. So it could be limited just to say helping with selling a home. So and so the limited power of attorney might be limited to certain transactions or certain financial acts, or it might be limited in time. And you might say, well, this power of attorney is only good for 6 months. In order to do a power of attorney document, the principal, the person signing it, has to be competent. which means they have to have the mental ability to know what the creation of this document means. And that means that they have to be of sound mind and at the time they're signing the document. So we talked about the principal. That's the person who names someone else to act on their behalf. The attorney, in fact, also called an agent, is the person named in a power of attorney document and authorized to act on behalf of the principal, the person who executed the document. And then broad versus limited authority. So broad authority, when you do a broad power of attorney, it means it's going to cover most or all of the things that the principal could legally do themselves, whether that's entering into contracts, paying bills, accessing bank accounts, versus limited authority. And another example of a limited authority power of attorney would be a parental power of attorney that's just limited to enrolling kids in school or getting them medical treatment. And then some other aspects of competency, and being competent to sign a power of attorney document. You have to be over the age of 18, and it can't be signed under duress or undue influence. So duress means under like a threat of harm. Undue influence means if someone is there exerting a lot of pressure on you to, for example, name them as their agent. And as we talked about, the person signing it has to have sufficient comprehension to understand what the document is that they're signing and what it does, and what the risks and benefits of signing that document might be. A durable power of attorney, unlike a regular power of attorney, it survives incapacity. So the power of attorney document will indicate somewhere in the document that it will remain in effect despite the incompetency or incapacity of the principal. So if you're going to go to the effort of getting power of attorney documents in place, it's really important that they be durable, because you need them to stay in effect even if you were to become incompetent or incapacitated. That's really the primary time when you would want power of attorney documents to be effective. And then a power of attorney can be springing or effective on signing. So springing means that the agent's ability and authority to act doesn't kick in until after some condition has been met. Either a certain date has passed or a certain occurrence, such as incapacity. The most common springing power of attorney we see is someone saying that the power of attorney will only become effective once saying that the power of attorney is necessary, saying that the person no longer has the ability to act on their own behalf. And then at that point, the power of attorney would kick in. We'll talk more about springing versus effective on signing, but essentially effective on signing just means as soon as you sign it, the person can start acting on behalf of the principal right away, as soon as it's signed. Okay. So the first type of power of attorney that we're going to talk about is the durable power of attorney for healthcare. So this type of power of attorney document only covers healthcare decisions and healthcare concerns. It allows you to name an agent who you trust to make decisions about your healthcare, including healthcare providers you want to use, medical treatment that you would like to have administered, or medical treatment you don't want to have administered. And unlike a living will, which we'll talk about here soon, a power of attorney for healthcare kicks in anytime you're unable to make decisions about your healthcare. And that could be because you're unconscious. Say you've come in from a traffic accident and you can't communicate with your healthcare providers. They would look to your power of attorney to see who you've named to help make decisions about your care. Or if you were incapacitated due to a condition like Alzheimer's, then again, they would look to your power of attorney document to see who you named as an agent to help make medical decisions on your behalf. So again, this power of attorney for healthcare, it only kicks in when you're no longer able to communicate your wishes directly with your healthcare providers. All right, so what are some considerations for when you're selecting a healthcare agent or in your power of attorney document? Certain categories of people under Idaho law cannot be selected as your agent. You cannot name your doctor or another healthcare provider providing treatment to you, or an employee of a hospital unless they are a relative of yours. You can't name the operator of a nursing home, assisted living, or community care facility, or an employee of those facilities unless they are a relative of yours. So those are the folks that by statute can't be named. Other than that, it's pretty much open. And what you really want to consider when you're selecting an agent is who knows what your wishes are about your healthcare and who would be comfortable carrying those wishes out. And then you want to make sure that they are willing to take on that duty of serving as your healthcare agent. Once you name a healthcare agent in your power of attorney, their decisions regarding your care and whether to give or withhold medical consent for certain procedures cannot be overruled by family or friends. Only a court-appointed legal guardian could overrule the medical decisions by your agent. So that's why it's so critical to name someone who will follow through with what your wishes are about your healthcare treatment. So the power of attorney for healthcare document is typically signed in conjunction with a living will, but you certainly don't have to do both documents together. But you'll see when I get to the forms section that both the form provided by the Attorney General's office and the form on Idaho Legal Aid's website include both documents together. So a living will is a written document where you outline your wishes regarding the use of life-prolonging medical care in the event that you're no longer able to make those decisions and you are in a persistent vegetative state and terminally ill. So this is, and we'll talk more about when it takes effect at the bottom here, but it is a document that's limited as far as when it's triggered. So the living will document provides an individual with three choices. One, you can say, I want all medical treatment to be provided, including artificial life support procedures. And an artificial life sustaining procedure is a medical procedure that uses mechanical means to supplant a vital function. So that might be artificial, breathing or other type of artificial means of taking over a vital function for the patient. It does not include the administration of medication or any procedures deemed necessary to alleviate pain. Those are always provided regardless of which option you choose. So in that first option, you're saying, do all of those artificial efforts to keep me alive. In the second option, you can say, well, I don't want the artificial life sustaining interventions, the mechanical means of sustaining life, but I do want nutrition or hydration or both. And so nutrition and hydration means an IV line to supply food and water, or a feeding tube, or spoon feeding or bottle feeding. Those are all considered artificial nutrition and hydration. And so you could say, I don't want the mechanical lung, but I do want nutrition and hydration, and that would be under option 2. And then the third option is I don't want the artificial life sustaining treatment, and I don't want the life support or the food or nutrition either. I don't want any of those interventions. And like I said, even if you were to choose option 3, they always pain alleviation is always provided. So in the living will, you choose one of those options. And then the living will only goes into effect once 2 doctors have certified that the patient has a terminal and incurable illness or is permanently unconscious or in a persistent vegetative state. That's the only time it's going to kick in. So in order for your healthcare power of attorney and your living will to be valid, you have to be over 18 when you signed it. You have to be of sound mind and acting of your own free will, and it has to be signed by you. And once executed, a copy should be provided to your healthcare provider so it becomes part of your medical record. And you can keep something in your wallet or purse indicating that you have an advance directive that's been signed. And on that wallet card, indicate where a copy of your power of attorney and living will can be found. And we'll talk about a registry that's available, but even if you weren't to use the registry, you could say, I have a living will and power of attorney, call this person to get a copy, or it's with my doctor, here's their name and phone number. So you guys should have received a list of different resources. This is on that list, but these are 2 places where the living will and durable power of attorney for healthcare form is available. And I just want to note too that it is required to be signed, but it's not required to be for this document to be notarized. So if you don't have a healthcare power of attorney in place, what would happen then if you weren't able to communicate your wishes to healthcare providers? That process is governed by the Natural Death and Medical Consent Act, which is in Idaho Code Title 39, Chapter 45. The specific code on durable powers of attorney and living wills is Idaho Code 39-4510. And those statutes say specifically you don't have to have both forms. You could just fill out one or the other if you didn't want to have both. If you did a living will or power of attorney before this this code section was adopted, it would still be valid if it's substantially conformed to the statutory language. And importantly, under the Natural Death and Medical Consent Act, no physician, health facility, or healthcare provider or insurance provider or nursing home or assisted living facility can require you to execute a living will and durable power of attorney for healthcare. It cannot be a condition of being insured or receiving healthcare services.
Hey, Sunrise, someone has a question.
Yeah.
So they asked, how often do these forms need to be reviewed and re-signed?
Yeah, I mean, I would recommend reviewing all of your advance directives, which would include your healthcare power of attorney, financial power of attorney, and a will if you have one, once a year. And if you still trust the agent that you named, you know any special instructions in there, you're still good with them, then you don't need to re-sign it and redo it. So really that annual review is just to check and see, well, have any of my circumstances changed? Maybe that person I named, I don't really think they're the best person anymore. If that was the case, then you would want to do new documents. But if that's not the case, everything still looks good, you can just leave it. So when you get the paperwork and you're ready to actually fill out the form, we mentioned this before, you can fill out both parts of it or just one or the other of the forms. Leaving any portions of it blank doesn't invalidate the document. So you'll see a section in the healthcare power of attorney for special instructions. And this is where you can list some limitations on the authority of your agent, such as specific types of treatment that you don't want to be used. So for example, I've had clients who had religious objections to blood transfusions, and that's something that they could put in their special instructions if they wanted to be really sure that their agent abided by that. When you're doing your healthcare power of attorney, you'll see a section where you can name alternate agents, and that's a really good idea. It might be hard for a hospital or doctor to reach the first person you name. So if there's more than one person you trust to help make medical decisions for you in an emergency, list them as alternate agents. So I mentioned this healthcare directive registry. So this is a place the state of Idaho maintains a healthcare directive registry accessible through a website, and it's a way for your healthcare providers, no matter where you are in the state, to be able to access your power of attorney for healthcare and your living will through the registry. So the Department of Health and Welfare currently maintains the Healthcare Directive Registry. The information right here is how you can register your healthcare directives with them. And then, like I said, they'll actually give you a wallet-sized card with a file number on it and a password, so that folks who had that file number and password could access your online directive. And so that could be a healthcare provider anywhere in the state, or even out of state, could access your healthcare registry and see who your agent is, what your wishes are. You don't have to register it for your healthcare directives to be effective, though. It's just a convenience of access option for you. So someone had asked a question about, okay, how often should I review these documents? And so what if you review it and you determine that you do need to make a change to it? Or what if you decide you don't want to have the document in place anymore, but you just want to revoke it? So at any time, you can create a new living will or revoke an existing living will. You have to be considered competent to create a new living will, but you can revoke it at any time, actually. So how would you revoke it? If you were to sign a new living will and durable power of attorney for healthcare document, that automatically replaces and revokes the one signed by you. If you were to write on the document that it's canceled or revoked, that also would terminate and revoke the prior power of attorney document. If you were to deface the document by burning it, tearing it, or obliterating it, that also revokes it. So what is the best way to revoke? The best way to revoke your power of attorney documents is to physically destroy all of the existing copies. And the reason for that is so that there's no confusion. If someone finds an older copy, if you've done a new one, but they find the older one first, they may not know that a newer one exists. So what we always recommend is do a new power of attorney document, make sure everyone who has copies of your old one gets the new one, and then any copies that you're able to have of the access of the old power of attorney, go ahead and tear those up or shred those. So a power of attorney for healthcare, there's really low risk of abuse or misuse. The most common complaints we do hear are people, being worried that it could be used to put them in an assisted living or nursing home that they don't want to go to. The fact that they can be used to access medical records, and people, using them to limit visitors when they're in an assisted living or nursing home. So the most important prevention tip on that is just choose your agent with care. Choose someone who, won't make decisions that go against your wishes. And then use those special instructions. So if something's really important to you about, hey, if I ever need long-term care, this is where I want to go, put that in your special instructions. All right, so the next section is going to be about financial powers of attorney. So are there any questions about the medical powers of attorney before we move on? Okay.
We do have a question.
Yeah.
So it says, can you name both children?
Yes, you can name more than one child, and we recommend naming one as the primary and the other child as an alternate, rather than naming them to act together as co-agents. And the reason for that is that when you name them as co-agents, they have to agree on the treatment or the path forward. And that can cause litigation, because if they don't agree, a court has to decide which way to move forward, or a hospital board, like ethics board. So it's usually better to just name one, so that those issues of there not being agreement don't cause a delay in care, and then just name the other child as an alternate.
And then someone else asked, did you say it doesn't need to be notarized?
It does not need to be notarized, just signed. And then dated, of course, so that you can tell if you had multiple, which was later in time. Okay, so the power of attorney for finances is a power of attorney document that's used for legal and financial matters. And so that might be paying bills, making bank deposits, watching over investments, collecting insurance and government benefits, or signing contracts for you. The power of attorney for finances is effective as soon as it's executed, unless your special instructions say otherwise. So you can name in your special instructions, you could, for example, say, I only want my power of attorney of finances to kick in when I turn 75, or I only want it to kick in with a doctor's letter saying I need help with financial matters, or some other contingency that you decide on. If your contingency is incapacity, it will be deemed to have occurred upon a written determination by a physician, psychologist, attorney, or judge. You want to make sure that your power of attorney for finances is durable, because like we talked about, if it's not durable and you become incapacitated, your power of attorney is no longer valid either. So make sure it's durable so that it can be used at those times when you need it. And then decide on the scope of your power of attorney document. Do you want it to be general, so that it covers all financial and legal matters? That does leave it more open for potential abuse or misuse. So you could instead decide that you want it to be a bit more limited in powers. When you look at the standard form in Idaho for financial powers of attorney, you'll see that you can go through and mark specifically each power that you want your agent to have. And you'll leave blank and unmarked those powers you don't think they need. And so I would recommend really thinking through that carefully about what powers does the agent really need. And in particular, there's a section about giving your agent the authority to make gifts of your property, and really think through whether that is necessary, because that obviously could be an area of potential misuse and abuse. So when you name an agent in a power of attorney document, they actually have duties that come with that. They owe you now fiduciary duties. And these are the duties that they owe you. They have to act on behalf of the principal and in your best interest. They have to act in good faith. They have to act within the scope of the document. So that's why we might limit the powers in the document. They have to act with care, competence, and diligence. They have to avoid conflicts of interest. So for example, they should not be, selling your house to themselves for $25. They have to keep records of all transactions, and they have to cooperate with any person who you've named to make healthcare decisions. And they have to preserve your estate plan. So those are the fiduciary duties they owe you. So what are some ways that we can prevent abuse or misuse of a financial power of attorney? Consider using a springing power of attorney that only kicks in, later in life when you feel like you might need that assistance. You can limit the scope of powers granted, like we've talked about. You can use special instructions to clarify your wishes and direct the actions of your agent. For example, you could say in the special instructions, I don't ever want my property sold to this person or sold for less than this amount. So you can put special instructions in there. The most important one is choosing a trusted individual as your agent. In the 15 years I've been doing elder law, what I've seen a lot is folks who feel like they have to name an oldest child, or they have to name the child that lives closest to them as their agent, instead of naming the person who maybe would be the most trustworthy or do the best job. And so I can't emphasize enough how important it is to really base the decision of your agent on who is going to be responsible and do the best job following your wishes, and not, let those other concerns about where they Um, so yeah, and I know that we've hit on that a couple of times, how important it is that the most important prevention tip is being really careful about who you name as your agent. We talk about this every few years or once a year. Review your power of attorney documents. Make sure that that person you named is still someone you actually trust. Monitor your credit reports and bank accounts for suspicious activity. A lot of us now have signed up for paperless monthly statements, and we might never log in and actually look at those. And so it's really important to be looking at your credit reports at least 1 to 2 times a year, and look at your bank accounts monthly for suspicious activity or suspicious charges, or like changes to the address, anything that doesn't look right. If you're at a point in your life where you no longer need access to credit, consider getting a credit freeze. It only costs $7, and it locks down your credit, so no new credit cards or car loans or any credit accounts can be opened in your name without giving a special PIN that will be assigned to you when you freeze your account. So that's a great way to to head off any potential identity theft or misuse of your information to open new accounts. If you find yourself in a position where you're like, you know what, I don't know if I trust this agent anymore, don't wait, don't hesitate to just do a revocation. And the link here is for a revocation form that you can use. Another option is you can build in oversight. You can add a provision to your power of attorney document that requires periodic reports or accounting sent to a third party. So you could say, well, I'm naming this child as my agent, but once a year or once every 6 months, they have to send an accounting to this child of mine or to this aunt, whatever it is. You could ask your attorney or someone you trust to hold your power of attorney in escrow. So instead of making it springing, you could say, well, I don't know when I want it to kick in, so I'm just going to sign it, have it be effective on signing, but I'm going to give it to this person or keep it in this safe place and only give it to my agent when I'm ready for them to start acting on my behalf. And you could name co-agents to serve together. And so one advantage of co-agents is that they can be a check on one another. But as we talked about, one disadvantage is that they have to agree. And so that can lead to some, costly litigation if they don't agree. These are some signs to look out for that might indicate that there's been abuse or misuse of your power of attorney documents. Unexplained withdrawals of large sums of money, bills going unpaid, sudden transfers of assets to other people, abrupt changes to wills or financial documents, disappearance of funds or valuable possessions, and someone accompanying a senior at the bank or at the lawyer's office, trying to pressure them into making transactions or making changes to documents. Some other red warning signs that you can look out for, a senior who has a new friend, who's becoming super involved in the person's sort of financial affairs, changing in banking and spending patterns, isolation. If your agent who you've named starts having drug or alcohol abuse, or starts becoming financially dependent on you or on the person who's named them, that might be a red flag of where you might want to change who the agent is. lacking funds for basic needs, an agent who refuses to provide account statements, or an agent who's attempting to isolate the senior. If fraud or abuse is suspected, you can demand an accounting. And we have a form letter that you can use to demand an accounting. You can review the credit report and statements to look for suspicious activity. You can revoke the power of attorney. You can even request that the court review an agent's conduct. You can sue, because like we talked about earlier, an agent has fiduciary duties to the principal. And so you have the right to sue them for breach of that fiduciary duty. You can also contact adult protection. Misuse or abuse of a financial power of attorney is criminal matter. And you can see under the code citation there for that. I would always say a good first step is just requesting the accounting. That way you can look over the transactions and see what's going on. And then hopefully everyone's aware that you can get one free credit report each year from each of the 3 credit reporting agencies at annualcreditreport.com. And we recommend not ordering them all at once, but spacing them out. So order one, then maybe wait 4 months, order from the other, wait 4 months, order from the other. And you can also sue an agent who has misused their power of attorney. There's an Idaho code that allows a principal or their successors to bring a civil suit against the agent. So for example, if they exceeded the scope of a power of attorney to do things that weren't authorized, or they used the power of attorney to access funds for their own benefit, or they failed to cover necessary living expenses with the principal's income. All of those things would be things that you could sue for. And the damages in that lawsuit would be restoration of the value of the principal's property that had been misused. And then you can also get reimbursement for attorney's fees. So we've talked about what some of the risks are and what financial power of attorneys, what it might look like when they are misused. And so that might make you think, well, this is kind of scary. Why should I even bother getting into a power of attorney document? And the reason why is that even though there are risks involved, when you plan carefully and you choose your agent wisely, you minimize those risks. And if you don't have power of attorney documents in place, then if you did become incapacitated in the future or unable to handle your financial affairs, without a power of attorney in place, your family members would have to go to court and obtain a guardianship and conservatorship over you. And we like to avoid that because that is a taking away of your rights. When you go under a guardianship conservatorship, it does limit some of your civil rights. And it can be an expensive court process, that can cost, a few $1,000s and on up. So having a well-drafted power of attorney where you've thought through who your agent's going to be, how you might limit the scope of it, saves you from potentially, having the necessity of a guardianship or conservatorship down the road. And then one quick last thing, one type of power of attorney that we didn't cover is a parental power of attorney. And so I just want to briefly say that is for when a parent wants to delegate parental powers to someone else for a set period of time. They can do that parental power of attorney form so that, if they were going to be traveling and they need someone else to take the kid to the doctor, register for them for school, all of that, that's what the parental power of attorney form is for. Our other power of attorney forms, the links are here and they're also on that handout that you received for the class today. And these are some other resources which also were on the handout. I have probably just 1 or 2 minutes if there are any questions about the financial power of attorney documents.
We're just gonna give them a quick minute here
Okay.
if they're typing it.
And I will say one quick thing on the financial power of attorney documents is that for those ones, they also don't need to be notarized, but we do recommend that the financial power of attorney documents be notarized. Because they are more apt to be misused, it's better to have that extra layer of proof that they were signed by you. And also, if you wanted your agent to be able to do anything with real property, like your home or any land you own, they could only do that if the document was notarized. So,
okay,
question about the
yeah, so someone said, where do you go for credit freeze option?
Yes, so the credit freeze, you request it from each of the 3 credit reporting agencies. So Equifax, TransUnion, and I'm forgetting the third one. But you would contact each of the 3 major credit reporting agencies. You request a freeze with them, and they'll send you a PIN number. And I've done it just because I have seen a lot of identity theft, and I just think it's I don't need to access credit a lot, so I would rather have that all locked down. And it's a really easy process. And if you've been a victim of identity theft, you don't even have to pay the $7 fee for the credit freeze. It's free. So for example, if you get a notice that you've been part of a security breach, you can request that credit freeze for free as a victim of identity theft.
Perfect. I don't think we have any other questions. Nothing else came on the chat.
Thanks everyone for your time. And one last thing that I'll say is that if you are age 60 or older, we have a senior legal hotline, and you can call us for free and get free legal advice on anything as long as it's not a criminal matter. So that senior legal hotline number is on there. So definitely call if you want help doing power of attorney documents, or you need more information or advice on it. And there's one other quick question. Does that stop you from using credit cards? No, you would still be able to use all your existing credit cards, but you couldn't open a new credit card account without first calling and using your PIN to unfreeze your credit. All right, thanks again, everyone.
Perfect. Well, let me turn on my camera really quick. I thank Sunrise for the wealth of information that shared with us, and I want to thank all of you that registered for this class. As a matter of housekeeping here really quick, NKA is welcoming new volunteers or suggestions for classes. So if you want to volunteer, or if you have any suggestions for classes, please email Kathy McDougall. She is the Associate State Director of Outreach for ARP Idaho, and I am putting her email address on the chat. And someone is saying, can I get a copy of the presentation? That will be available in YouTube in a few days. So that's where you will be able to see that. And then I'm going to have another NKA class this Friday, and that is about selling your timeshare. So if you ever wondered how to sell your timeshare, join that class. I'm going to copy the link so that you can go and let me put it here. So that is the link where you can go and sign up for the class. Someone asked, what is the YouTube address? I believe it's just youtube.com, just like that is where you can go and search it. I'm not exactly sure when this class will be available on YouTube. My guess is probably going to be next week, but it should be available within a week. Once again, thank you for joining us, and we hope you have a great rest of your afternoon. Bye-bye.
Thank you.